So with the Supreme Court allowing a blatantly anti-woman, anti-abortion law to go into effect in Texas, have we finally reached the point that we need to expand the court? Let's talk about it in today's video. Hi, I'm Mike Reiner. I'm a lifelong Democratic activist who is concerned about the direction our country is taking. If you share my concerns, maybe you could like this video and subscribe to this channel, maybe even click that little bell that will notify you when I post something new. So with a short 400-word ruling and no oral argument, 5 justices of the Supreme Court basically eliminated Roe v. Wade and the constitutional right to an abortion in this country. Some of you may be celebrating that fact. But the reality is it makes you wonder if it's really good for the Supreme Court and for the country in the long run for such a thing to be done completely silently on such a thing that's called the shadow docket. There were no oral arguments held. It was just a short one-page opinion issued that said that the law would be allowed to go into effect. It's worth noting, by the way, that 4 of the 5 justices who signed this opinion were nominated by presidents who lost the popular vote. 3 of those justices, by the way, were brought in by Donald Trump with the assistance of Mitch McConnell. And at least one of them is there as a result of the blocking of President Obama's nomination of Merrick Garland. So if you think that the Supreme Court is not political, you're kidding yourself. In fact, I would argue that part of the reason that the Supreme Court is employing this shadow docket is specifically because of the fact that they are political. The Supreme Court knows that this is going to be a controversial decision, and so they don't want to hold hearings on it. They want to do this in the quiet of the night when people aren't watching. I think it's very telling that Chief Justice John Roberts, no liberal himself, in fact, a lifelong conservative known as an activist conservative who actually worked in the Reagan White House, that he voted with the 3 liberal justices to stand in the way of this law going into effect. The reason being is that he is, above all, a court institutionalist. He cares about the value of the court to society, and he knows that taking these kinds of steps will undermine its long-term legitimacy. This is not, by the way, the first time that the court has used this shadow docket to make decisions on unpopular, controversial decisions, making these decisions without even holding a hearing. Some recent examples of that, including the blocking of the New York State eviction moratorium and ending the federal eviction moratorium. Also, requiring the Biden administration to reinstate a Trump-era immigration policy and blocking California's pandemic restrictions on religious gatherings. All those things were done in the dead of the night, without argument, with very short opinions signed by only a small number of justices. Some of these decisions raise important issues, like the California pandemic restriction specifically debates the religious rights and the powers of government under the First Amendment. But yet we never even got an opportunity to discuss that in open court. It was simply signed by the justices who decide to follow their ideology. And completely undercutting the power of government to stand in the way of evictions is something that just diminishes the power of the government and shifts so much of it more to the courts. In the United States, we consider ourselves a nation of laws, and as a result, we give a lot of deference to the courts. I myself am an attorney, and certainly I respect the laws and the courts. But part of my experience as a lawyer has shown me how so much of the decision that gets made by a court depends upon which judge you're in front of. And in this case, the right wing has made sure that the Supreme Court is stacked against us. Now, you might think that this Constitution has established it that way, and the reality is that's not the truth. All the Constitution says about the courts is that there shall be a Supreme Court, that the judicial power of the United States shall be vested in it, and in such inferior courts as the Congress may from time to time ordain and establish. That is Section 1 of Article 3 of the Constitution. It says nothing about lifetime appointments. It says nothing about there being 9 justices. It says nothing about there being the district courts and the circuit courts and the Supreme Court. None of that is in the Constitution. All of that is in statute, which can be changed by a simple majority in Congress. In fact, the whole idea of judicial review, where the courts would step in and say that a law is constitutional or unconstitutional, never came up in the Constitution, never even came up under law. The place that emerged from was from an early decision of the Supreme Court called Marbury versus Madison, where Chief Justice John Marshall at the time basically wanted to sidestep an issue and said, look, we're not going to rule on this issue the way you want us to rule on because, hey, the law is unconstitutional anyway. That decision became the basis of so many laws, including the ones that I just cited, which were overturned, where the Supreme Court in the dead of night overturns the action of legislatures and Congress. So what's stopping Congress from making changes that would make the Supreme Court fairer and more reflective of the majority of Americans? Well, it's the filibuster. It's pretty clear that changes to the court that might, for example, create term limits for justices and might create a rotation that would make it fairer where different presidents would all get an equal opportunity to appoint justices to the Supreme Court, that this legislation would likely pass both the House and the Senate if it were just up to that. The problem is that there's the filibuster, and the filibuster allows just one member of the Senate to stand in the way of anything moving forward. You don't even need to have 40 senators backing that effort, as was shown when the January 6th Commission was attempted to be established, where only 35 members of the U.S. Senate voted against it going forward. But the way it's been set up in the Senate rules thus far is you need 60 votes basically to do anything. And until that gets changed, we're going to be stuck. We need to make it clear to our members of Congress and to the Senate that they need to address the filibuster to allow us to make the changes that will make America a fairer place. Because basically, we're just handing off our power to the right wing and the extremely wealthy, who are using this shadow docket to make laws that directly affect the constitutional rights of Americans without even having the opportunity to argue it in an open court. Well, if you agree with me or disagree with me, I'd love to hear your comments down below. And if you could give me a like on this video and maybe subscribe to this channel, that'd be a huge help. I'll see you in the next video. In the meantime, let's hope for continued progress. Thank you.